Thank you for that introduction, Duncan. And the question, is one which, can lead to quite a number of things being said in response. But perhaps one has to look at what FDI actually is and understand that, at least from what I understand of FDI, it connotes somebody who is a foreign investor who intends to make a long-lasting investment in Pakistan rather than someone who is just perhaps engaging in a standalone transaction. So they'll be investing in the country either by establishing a business or collaborating with an existing business, and that would mean that they would have larger interest in the overall dispute resolution mechanism that exists domestically. A number of themes were already touched upon in earlier panels about how you need to have ADR statutorily embedded across various areas where disputes could arise. The speaker from Turkey had illumined us on how they have combated the vast quantum of cases that were pending in their court system, and how that was eradicated largely through the establishment of mediation centers and utilizing mediation as the dispute resolution mechanism of choice. And as it happens, I was part of a delegation to Turkey which had gone perhaps a year and a half ago. And there we had visited some of these mediation centers, and we were informed that by statute, disputes such as consumer protection cases, labor disputes, and as we were informed today, even rent cases, have to necessarily be taken through a mediation process before a party can come to court. As far as Pakistan is concerned, certain legislative steps have been taken to enforce a system of mediation, but that has been left mostly as a matter of consent as between the parties. The courts have limited ability to push parties towards mediation. They can actually call upon them to mediate, but at the end of the day, if they choose not to, what is the recourse which the courts would actually have? Because you also have to factor in that we don't really have a well-entrenched system of costs. I remember attending a conference on ADR way back in perhaps 2005-06, and Justice Mushir Alam was then the Sindh High Court. Perhaps Justice Sabiuddin Ahmed was the Chief Justice. And at this conference, as a naive junior lawyer, I think I stood up and had the temerity to ask as to why anybody would venture towards mediation or alternate dispute resolution in our litigation landscape, where somebody can come to court, pay a very nominal amount of court fees, and even if the case is lost at the end of the day, after having exhausted perhaps a decade of the court's time, they would just walk away with very little by way of consequences. So, a cost system needs to be introduced as a deterrent to vexatious litigation to ensure that the backlog that afflicts the courts is attended to, but also it's one thing that would actually prompt people to take ADR seriously. If they realize that every dispute isn't necessary to be litigated through a court of law, and this is a means of dispute resolution which ought to be explored, and if it is not explored in good faith, that there would be some consequences that the court can bring to bear against them, then I think ADR, whether it's mediation or conciliation, whatever model we hope to implement, would definitely have a much better chance of success. Beyond that, obviously, there are several other basic measures which any government can take, whether it's sensitizing the litigating public towards the means available for them to resolve their disputes through whatever ADR platforms are implemented, bringing the various stakeholders on board, whether it's the bar councils, bar associations, trying to create awareness amongst legal practitioners that this is the way forward. It's not a measure which necessarily ought to be resisted by them. So, I think that's those are a few of the core issues which governments could address. As I said, the statutory steps, awareness building, training, and so on.
Could I ask a brief follow-up question, if I may? In London, where I practice, the commercial court is a highly restricted court. It generally sits on arbitration cases and other cases in which the amount in dispute is at least £2 million, if not more. And the judges actively push cases to other divisions of the court in smaller cases. Do you think in Pakistan there's scope for a narrower, restricted division of the court that could deal with arbitration in large commercial cases?
Well, it's interesting that you asked this because as far as at least the Sindh High Court is concerned, we have what's called the original jurisdiction which the Sindh High Court enjoys. And that is structured on the basis of a pecuniary value, and it's a rather nominal amount compared to what you mentioned as far as the commercial court in London is concerned. Here, the Civil Courts Ordinance had originally structured this jurisdiction by regulating it in such a manner that any suit which had a value of over 25,000 rupees would originate in the Sindh High Court, irrespective of the subject matter. And now, over a period of time, that valuation has been enhanced to maybe 6.5 crores, 65 million as you would call it. But again, it's not rationalized by reference to what the nature of the underlying dispute is. So even though the Sindh High Court is really the commercial court, at least in the city of Karachi for all practical purposes, the jurisdiction is overrun with cases that have no commercial nexus whatsoever. So I think there is definitely a lot of scope for commercial courts to be created, and we have, in a judgment which has been rendered by the Sindh High Court, we have called for the provincial government to take the necessary legislative steps by tabling appropriate legislation before the Provincial Assembly to carve out a commercial court structure which is actually more rational in the sense of being based on classification rather than simply a pecuniary value. Well, Kevin, if you're speaking more about international arbitral awards, then yes, we have a 2011 Act which provides for the recognition and enforcement of New York Convention awards. There is now a pro-enforcement bias, which is something which has been brought to the fore in several judgments which have been rendered by various high courts and also now emphasized by the Supreme Court in a very recent judgment. But it comes back to what I was saying earlier, having a judge being cognizant of the fact that there is a pro-enforcement bias is one thing, but when you have courts which are burdened with an overwhelming amount of litigation on their docket, then their capacity to effectively enforce a foreign award is impeded because of the delays which are inherent in the system. So, a lot of times foreign awards don't come up for hearing as quickly as they should. So coming back to the Sindh High Court, perhaps we haven't really enforced too many foreign awards since the inception of the 2011 Act. I had asked our registrar and our legal research cell to give me the number of cases where foreign awards had been enforced under the 2011 Act, and the picture was quite dismal, to be honest. So I think the courts actually need to be strengthened. They've already been sensitized as to what the scheme of the New York Convention is, how the scope for objections is very limited, how it's important to have a minimalistic approach in terms of being reluctant to interfere with awards unnecessarily and enforce them. But at the end of the day, you have to have the benefit of time on hand. So if you have a docket of maybe 50, 60, 70 cases and the enforcement matters come up towards the end of the day, I think a lot of times delays are caused because of this process, which needs to be streamlined. So it's not simply a fact that the courts aren't up to it. It's because the system as a whole needs to be reevaluated and restructured. Well, again, coming back to what I said earlier, at the end of the day, you'll always have only one party which perhaps desires a quick and expeditious conclusion of the case. One party will always be seeking to resist the enforcement of the foreign award or domestic award till till kingdom come if they can manage it. So unless you have some coercive tools at your disposal in terms of imposing costs on counsel or parties that are found to be protracting the proceedings unnecessarily or being delinquent in their duties to the court, you'll find that judges are somewhat handicapped in that respect. So again, it comes back to the first question that you posed: what can the government actually do to strengthen the courts in their ability to move things forward? I think if we had a statutory mechanism in place which provided for costs to be imposed across the board, that would be a step in the right direction. Yes, we can come up with practice directions for lawyers as to how they should present their briefs, but again, I think that would perhaps only have a limited benefit for the time being. I think just to add to what Shahbaz was saying, I think this is perhaps a product of our adversarial mindset and the kind of training which we have here as lawyers. Rather than trying to come up with a solution to the problem, I think we just try and prolong the dispute as long as we can. And as he was saying, oppose every measure, any order which is passed. You have a tendency of appealing that irrespective of what your chances are at the end of the day, because you just want to linger the matter on as long as possible. And while that pays dividends here within our local jurisdiction, it ends up as a disaster when you're litigating or arbitrating before an international tribunal, because there the consequences are inevitable.